right, folks, welcome back to another in our series of lectures on litigation and education law. That's the Supremes in the background. We're going to look at more court cases brought down by, the lower courts, the Court of Appeal, and the Supreme Court of Canada as well. Today, we're going to talk about teachers as role models, which is a really big topic in education law. We are in a very strange situation as teachers. Other professions, you don't have to be a role model to be, a farmer. You don't have to be a role model to be a mechanic. I mean, you may want to your children or to your neighbors or to your community and that, but you're not under any, you're not beholden to be so as part of your job. But we're in this weird situation when we're teachers that we're required to be role models, and we're actually held to account to be role models. And if we find ourselves, or if we're found out not to be good role models for students, even outside of school hours, off duty, God, there are repercussions. We can suffer the consequences. So this is an investigation into that for you. A few years ago, I was out in Vulcan, Alberta. We went to the Enterprise, the Star Trek museum there. It was kind of interesting, I guess. But one of the places that I liked better than that was we took a little trip into the museum. I think the museum's under construction right now. They're fixing it up, but they have a little one-room schoolhouse there that I found really interesting from back in frontier times. And they had some posters up, for the rules for teachers back in the early days of teaching, before Alberta was Alberta and it was just the Northwest Territories. So I thought I would read those for you here. These are rules for teachers from 1872. Teachers were expected to be role models, right? When you went away to teachers' college, it was called normal school, which is weird, but rules for normalcy, right? Like we were supposed to be role models for what people were, what the kids that we were teaching were supposed to grow up to be. They were supposed to be like us. So normalcy. 1, teachers each day will fill lamps and clean chimneys. 2, each teacher will bring a bucket of water and a scuttle of coal for the day's session. 3, make your pens carefully. You may whittle nibs to the individual taste of the pupils. Little things that we no longer do. 4, men teachers may take 1 evening each week for courting purposes, or 2 evenings a week if they go to church regularly. Number 5, after 10 hours in school, the teachers may spend the remaining time reading the Bible or other good books. Sounds like fun. Number 6, women teachers who marry or engage in unseemly conduct will be dismissed. Oh my God, eh? So if you were ever caught doing something that somebody didn't like the look of because you were a woman, you'd be canned. Or if you ever got married, God forbid, what? Anyway, I guess you're supposed to be single to be a teacher. And the moment you get married, then it's time for you to quit. Number 7, every teacher should lay aside from each pay a goodly sum of his earnings for his benefit during his declining years, so that he will not become a burden on society. So you got to be saving your money. If you're not saving your money for when you're too old and nobody wants you, then you can't be a teacher. We don't want your ilk, I guess. Number 8, any teacher who smokes, uses liquor in any form, frequents pool or public halls, or gets shaved in a barber shop will give good reason to suspect his worth, intention, integrity, and honesty. Yeah, those rotten billiard halls and barbers. Number 9, the teacher who performs his labor faithfully and without fault for 5 years will be given an increase of 25 cents per week. Woohoo! In his pay, providing the Board of Education approves. So that's in 1872. In 1915, I don't know, things changed much. Let's see. You'll not marry during the term of the contract. I think, it looks like this one is particularly focused on women, right? So it should say rules for women. You're not to keep the company of men. You must be home between the hours of 8 p.m. and 6 a.m. unless attending a school function. You may not loiter downtown in ice cream stores. Oh my God, eh? You may not travel beyond the city limits unless you have the permission of the chairman of the board. Sounds like indentured servitude. You may not ride in a carriage or automobile with any man unless he is your father or brother. What would people think? You may not smoke cigarettes. You may not dress in bright colors. No happiness. You may not, under any circumstances, dye your hair. You must wear at least 2 petticoats. Wouldn't want anything showing. 11. Your dresses must not be any shorter than 2 inches above the ankle. And the last one, to keep the school room neat and clean, you must sweep the floor at least once daily, scrub the floor at least once a week with hot soapy water, clean the blackboards at least once a day, and start the fire at 7 a.m. so the room will be warm by 8 a.m. So pretty stringent measures for the old one-room schoolhouse back in the 1900s and 1800s. Alright, teachers as role models, eh? The role model principle assumes that any type of immoral or unprofessional behavior that occurs within a teacher's life is detrimental to the student's learning environment. The crucial element in deciding whether the teacher's conduct in his or her private life is inappropriate is a determination as to whether a private behavior is linked causally with his or her inability or unfitness to teach. If the teacher's conduct has resulted in lost credibility, this can negatively affect his or her ability to teach. As Brown and Zucker 2007 point out, teachers are role models for their students, but this doesn't mean that the teacher should be dismissed simply because the school community perceives a teacher as lacking good moral character, right? I mean, just because somebody thinks that you're not a good guy or a good woman, that they have some kind of, suspicions about you, or they don't like something, there's no reason for them to can you. But, I mean, here we have this poor girl, Ashley Payne. This was on the Daily Mail reporter. This teacher, young girl, sacked for posting pictures of herself holding a glass of wine and a mug of beer on Facebook. I mean, what's she doing? She's with a pint of beer in one hand, a glass of wine in the other. The worst thing you could accuse Ashley Payne of is mixing her drink. But this happy holiday snap has cost the high school teacher her job after a parent spotted it on Facebook and complained. What a nosy person. Anyway, and what was she? She was on vacation traveling around Europe in the summer of 2009, right? This is 2011, so this is even before she was a teacher, it sounds like. Maybe. She was off exploring as young people do, go off on a trip around Europe. It's an exciting time. It's a time of exploration and seeing the world and everything. She's 24, and this is like, oh, well, you can't be a role model because, anyway, you see what I'm saying is, I mean, those rules from the 1870s and the 1900s seem so asinine and ridiculous, but here, look at this. Someone even in our day got canned for just, being, I don't know. I hope that she got a good job somewhere else. That's really, really ridiculous. So, factors considered in dismissals, right? What sorts of things, when, there might be a dismissal, when you might get fired, what sorts of things are considered? Well, the likelihood of a recurrent behavior. So you did this once, are you likely to ever do it again? All right, if you're likely to be a repeat offender, dismissal is more of an option, I guess. Extenuating circumstances, right? Well, this happened, but what were the circumstances behind that, right? A good principle would go and find out, why did that happen? Maybe there were good reasons why that happened, right? Maybe you're not such a bad guy. Like maybe someone who's a good person, and would be apt to do such things, right? Finding out more facts. Effective notoriety or publicity. So whatever you did, how does that look? What does that publicity do for your image, for the image of the school, for the image of teachers in general? For does it bring a bad image to the profession? If it does, then likely you're not going to have your job long. Impairment of student-teacher relations, right? Having done or said such a thing, what does that do to your ability to teach? Does it poison the environment? And disruption to the educational process. How disruptive is this? Is this something that can be moved beyond, or is it, as long as you're here, this is going to be a problem, we got to get rid of you? Motive, what was the motive behind this thing? Sometimes we do the wrong thing, but for the right reasons, right? Proximity and or remoteness of the time of conduct, right? Like, well, this thing happened way back when I was a teenager, or this thing happened 10 years ago, or, how relevant is it to me now? So here's a question for you. How fair is it that teachers are held to such high expectations in their profession? Have a class discussion about this. How will these expectations affect your own life if you choose to enter into a career in teaching? Here's a court case from 1982. In 1978, Mr. Bonnier, a Roman Catholic teacher in a Roman Catholic school in Laval, posed nude with his cohabitant, Miss Nude Quebec, who had been a student of his, the previous year. The picture was taken at a private nudist club and was published in a Montreal newspaper, Le Nouveau Samedi. The school board suspended Mr. Bonnier without pay for 6 weeks, and Mr. Bonnier appealed the suspension to a board of arbitration. The arbitration board, ruling carefully, considered Roman Catholic doctrine, but also took contemporary morality into account. The arbitration board said nothing had been presented during the hearing to indicate that Mr. Bonnier's nudity was contrary to its understanding of Roman Catholic doctrine. In addition, it indicated that the incident had taken place during the summer, so there was little disruption to the school. Further to this point, the arbitration board said the Laval School Board had been effective in quieting any parental concerns. It said, however, that had there been a greater public outcry, Mr. Bonnier might have lost his job. Yeah, today, folks, I don't think he'd be keeping his job. Today, people love a controversy, and that's controversy, just if I've ever heard of it. But back then, I guess, in Quebec, in the 70s, I guess it probably wouldn't have raised too many eyebrows. Particularly because I guess he was considered a good teacher, and people in his area were all right with it, I guess. Anyway, I wouldn't do that if I were you. Abbotsford School District v. Shewan. This is a more recent case. It's a very famous case from 1987. John and Ilse Shewan were long experienced good teachers, and they were both active in their community. And their husband and wife, they submit nude pictures of the wife to gallery, or actually semi-nude pictures of the wife to Gallery magazine in 1984 for a Girl Next Door amateur erotic photo contest. Now the picture is described in this book, Teachers in Trouble. It's a good book, as similar to those that used to appear in pin-up calendars of an old-fashioned sort, and was only modestly revealing. So it wasn't like some of this really horrendous pornography that was all over the internet and in magazines and things. It was more like one of those old photos from the 1940s. Nonetheless, a radio reporter saw the picture and told the superintendent, and then the suspended teachers, I guess they were suspended for 6 weeks without pay, right, as a punishment. Well, the Shewans, they grieved the decision to a board of reference who overturned the initial school board decision and demanded back pay for them. One member of the reference board found that it was misconduct, but reduced their suspension from 6 weeks to 10 days. Then Abbotsford School Board appealed this decision to the Supreme Court of BC, and the judge, he sided with the school board. He found them guilty of misconduct, but he set the time for suspension to 1 month. And he upheld, this was upheld at the Court of Appeal. So the long and short of this case is that teachers are expected to be role models for their students and in the community. And this includes their behavior outside of the workplace as well, right? So not just the things you do in the classroom, but outside of the classroom, outside of school hours on your own time, you're held to account for those things as a role model, see? Here's a horrible one. This is the Audette case from 1996. In this case, a really young teacher, right? 22-year-old New Brunswick phys ed teacher. And he was charged with sexual exploitation for having oral sex with a 14-year-old female student while on summer vacation. So, in other words, he taught her, and then summer rolled around and he was no longer her student. And he was found guilty by the Supreme Court of Canada because he remained in a position of trust and authority even outside of school hours. So the criminal code section that this court case revolves around is section 153, and it should be right here. I'll just read it to you. Every person commits an offense who is in a position of trust or authority towards a young person who is a person with whom the young person is in a relation of dependency, or who is in a relationship with a young person that is exploitative of the young person, and who A, for sexual purposes, touches directly or indirectly with a part of the body or with an object or any part of the body of the young person, or B, for sexual purpose, invites, counsels, or incites a young person to touch directly or indirectly with a part of the body or with an object, the body of any person, including the body of the person who so invites, counsels, or incites, and the body of the young person. So, make a long story short, like this young teacher, even though he wasn't her teacher at the time because it was summertime, he was still found in a position of trust and authority because he had been her teacher, and actually he was going to come back the next year and be her teacher again in the next grade. So here are the facts. The accused went to a nightclub with a friend a few weeks after the summer holidays began. By chance, right? It wasn't, it was just by chance. He there encountered the young person, then 14 years of age, whom he had taught during the school year when she was in grade 8. She was accompanied by 2 of her cousins, both in their 20s. Okay, so her cousins are about the same age as this teacher. At about 2 o'clock in the morning, at the suggestion of the accused friend, the group went to a cottage. Right, so the teacher's friend said, let's go to my cottage. The young person stated during her testimony that the accused complained of a headache. So the teacher got a headache. They were probably out drinking, got a headache, right? And went to lie down in a room containing 2 beds. So there's 2 beds in there. He's got a headache. He goes, falls asleep. Shortly thereafter, the young person joined the accused and lay down in the same bed, right? So there's 2 beds, but for some reason that 14-year-old girl decides, I'm not going to lay down in the bed, the empty bed, I'm going to go lay down in the bed beside this young teacher. And she also fell asleep. Well, during the night, the accused and the young person woke up and they engaged in oral sex, and then the the complainant became increasingly uncomfortable, right, the young girl, and entreated the respondent to stop, which he did immediately. In a statement to the authorities that was adduced in evidence at trial, the accused admitted that he had initiated the touching, and the respondent then asked the complainant to say nothing about the incident, right, so don't tell anyone, and told her that they might see each other again before the beginning of the next school year. At the time of the incident, he'd already been informed, he already knew that his contract of employment had been renewed for the following year, and that he would again be teaching the students in grade 8s, or 7, 8, and 9 at the young person's school. So this is a pretty ugly court case. But the accused was acquitted at the lower court, so the teacher was found innocent at the lower court on the ground that he was not in a position of trust and authority towards the young person at the time of the incident. And then the Court of Appeal affirmed the acquittal in a majority decision. But then this went to the Supreme Court of Canada, and they overturned both acquittals and found Audet guilty. The majority of the court found that he was indeed in a position of trust and authority over the girl, even though he wasn't on duty as a teacher at the time. And he would in fact be a teacher again in the fall, as it turns out. So your duties towards, it's an ugly, really horrible court case. I don't even like thinking about that sort of stuff. But it's an important one also because it shows that teachers are beholden to be moral, ethical, upright people who make good decisions outside of school, in their own private lives, as well as in school, and that their role model status doesn't end with the summer recess, and that their authority as teachers doesn't end when the school bell rings at the end of the day. That it's something that they carry with them as long as they remain in the profession. So keep that one in mind. I don't imagine any of you would ever do such a thing, but keep that in mind. Here's another one: the Toronto Board of Education versus the OSSTF. This is the Bedoria case from 1997. This Jagdish Bedoria fellow is kind of an interesting character. He was a teacher, but he was also a parliamentarian who is left politics under equally ugly circumstances, it seems. So the Supreme Court of Canada ruled against a teacher who wrote nasty, threatening letters to the school board complaining about being consistently turned down 39 times. He's consistent, persistent, for promotions to the position of vice principal. So this guy really wanted to be vice principal, and they kept on turning him down. And he wrote nasty, threatening letters to the school board. I don't know what he was thinking. Like, that's going to make anything better? He was found not mentally unstable and was subsequently fired for acting badly and unreasonably outside of school hours or off duty. The Supreme Court of Canada upheld his termination because his threats of violence, were not aligned with the expectations of teachers as role models. See, teachers we're role models. We shouldn't go around threatening people with, violence, And so that's an interesting one as well, that says that what you do outside of the classroom on your own time matters as a teacher, that your private life and your public profile as a teacher are not separate entities as in education. Here's another interesting one. This is Kempling v. College of Teachers from 2005. Here a BC school teacher, an advocate of so-called conversion therapy, Chris Kempling was disciplined with a 1-month suspension for making off-the-job anti-homosexual comments in articles and letters to the editor in the local newspaper, the Quesnel Caribou Observer, between 1997 and 2000. This conversion therapy stuff, this is some weird idea that you can, if you're a gay or a lesbian person, that you can be talked out of it, that it's not part of your makeup, who you are. It's more like a choice that you make. And so this Chris Kempling fellow, he had that particular view, and he actually, I think he was a counselor too, which is bizarre, but he used to promote this as well, but he wrote rather hateful things about gay and lesbian people in the local newspaper, and he was disciplined for it, even though this was on his own time, right? Kempling has since been cited again, or rather, I should just finish here. He claimed that the disciplinary actions taken against him contravened his Charter 2A freedom of religion, as well as his freedom of expression, 2B, right? He said it was freedom of religion because he said that his anti-homosexual views were all somehow grounded in his religious beliefs, his Christian beliefs. And then also he felt that his freedom of expression, his freedom of speech, to write, things like this in the newspaper and have them published, was being violated by these punishments. But his complaints were all dismissed by the court. Kempling has since been cited again by the BC College of Teachers for further discriminatory comments on CBC radio broadcasts and various websites. Recently, Kempling left public school teaching to teach, quote, privately. So there are some implications of the Kempling case for teachers in Alberta, too. This is from the ATA website. All students, regardless of their sexual orientation and gender identity, are constitutionally entitled to a non-discriminatory school environment. Members of the teaching profession may be charged with unprofessional conduct if their on- or off-duty conduct is found to have created in word or deed a poisoned educational environment, right? So think about if you said such hateful things, or you said such intolerant things about gay and lesbian people, and then you have, how would that affect, and you did so off student hours, right? Or off school hours. And then these things became public knowledge that you'd said this. How would that affect your ability to teach? If you ever had a gay or a lesbian student in your class, how would that affect your relations with him or her? If you were trying to teach students about human sexuality and things like this, how would that affect your ability to teach those subjects, right? If you're teaching about the Charter of Rights and Freedoms and good citizenship, how would that affect your ability to do your job, right? So it could poison the educational environment, and that's what the BC College of Teachers was saying effectively here. So in keeping with evolving understandings of human rights and the increasingly pluralistic nature of Canadian society, the ATA Code of Professional Conduct was amended to require teachers to teach in a manner that respects the dignity and rights of all persons without prejudice to sexual orientation and gender identity. The ATA became the first teacher association in Canada to include protections for students based on gender identity. The Canadian Teachers Federation and many other teachers associations also now provide similar protections. And the ATA's position paper on diversity, equity, and human rights from 2003 reaffirms the association's belief in the inherent dignity and worth of each student and emphasizes that schools should be inclusive learning communities that foster a climate of respect, trust, caring, sharing, and democratic responsibility. Schools that exhibit these characteristics are places of empathy, and safety in which differences are valued as an integral part of the learning experience. With reference to one of Kempling's central points that sexual orientation can be changed and the success rate for those who seek help is high, unquote, teachers should note that both the Canadian and American psychological associations have issued clear statements and professional guidelines denouncing the use of effectiveness of, quote, reparative and conversion and reorientation therapies that purport to heal or cure a person's sexual orientation or gender identity, right? So essentially all the, clinical research and things like this say that this stuff Kempling believed in, this so-called conversion therapy, is horse crap. Research has shown that these approaches are ineffective and ignore the influence of social stigma on mental health, and in many cases can be extremely dangerous in a form of professional malpractice. Okay? So there are some of the implications of that court case. It's a big one. Now another one of the really big ones in Canadian law is Ross v. New Brunswick, 1992. So Malcolm Ross was this teacher in New Brunswick, and he was fired from his position after making repeatedly racist and discriminatory comments against Jews during his off-duty time over many years. All right, so on his own time, he was this rabid anti-Semite. Right, he wrote all kinds of rot about Jews, just like Kempling wrote all kinds of rot about gay people. Ross had written many books, in fact, and pamphlets, as well as letters to the local newspaper fomenting anti-Semitic views. He even appeared on a local television show for an interview. There's one of his books there. Look at the cover of it, right? A Jewish parent whose child attended a different school filed a complaint with New Brunswick Human Rights Commission, claiming that the school board, by employing Ross, was violating the Human Rights Act. I think how that was able to happen, I seem to recall that even though the parent's child didn't attend Ross's school, nonetheless the schools, like all the schools in the area, were associated with one another. Like, so say you wanted to play sports or you wanted to be in extracurriculars of some kind, right? So it wasn't necessarily the case that the schools still were associated with one another, and the parent claimed that therefore it wasn't, he wasn't out of place, claiming that discrimination against Jews here because his kid wasn't in the school. It was in fact the case that his kid would be affected by what was going on in Ross's school, by the very nature of the fact that all the schools in some fashion were all participating in other ways with each other. Okay, so the parents' lawyers argued that Jewish people were being discriminated against by Ross's diatribes, and that his continued employment by the board made them complicit. All right, so they knew that this was going on, they're saying, and as long as you continue to harbor this guy who promotes hatred towards Jews, you're complicit in the promotion of hatred. A review panel found Ross's off-duty comments repugnant and discriminatory towards Jewish people. The school board was also held to blame for not having disciplined Ross earlier in his career when Ross's behavior became known to them. Ross was placed on a leave of absence without pay for 18 months. The school board was told to rehire him in a non-teaching position if one came available. They were also told to fire him immediately if he hadn't been rehired to a non-teaching position, or if he continued to publish or sell any of his anti-Semitic propaganda. And Ross, he claimed that his treatment at the hands of the board violated his chartered rights to freedom of religion and freedom of expression. The New Brunswick Court of Appeal overturned the review panel's decision, agreeing with Ross's lawyer that his Section 2 rights had indeed been violated and that the violation couldn't withstand a Section 1 reasonable limits Oakes test. All right, we'll talk about that in a sec. The Supreme Court of Canada ruled, however, that Ross's removal from the classroom was justifiable on the grounds that although it did constitute a violation of his freedoms, this was a reasonable limit, as school teachers must be held to a higher standard of behavior. All right, so, I mean, if you're, I've been a garbage man, so I can say this, if you're a garbage man, you're not held. You can say all kinds of trash, and you can say what you will, but you're not held to the standard of behavior that a teacher is. Or not just a garbage man, but very, very, very many other professions and jobs. You're not held to the kind of standard that we are as teachers. Now, what's this Oakes test? Well, it has to do with how our Supreme Court interpreted the law in R.V. Oakes, this 1986 case. In particular, Section 1 of the Charter of Rights and Freedoms, which they call the Reasonable Limits Clause. Let me just read it to you. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So, in other words, we all have rights to this and rights to that. You can look up all the different rights in the Charter of Rights and Freedoms. But, they're not exactly inviolable either, right? You have a right to freedom of religion, or a right to freedom of speech, or a right to this or that. But the age-old one, right? You can't yell fire in a crowded movie theater, right? Freedom of speech doesn't protect that. There are reasonable limits on what you can say, or reasonable limits on, you can have any religion you want, but you can't have human sacrifice as one of your sacraments or something like that, right? There are reasonable limits, or things that are harmful towards other folks. So when your religious views are discriminatory against people who are gay or lesbian, or when your religious views are discriminatory towards people of other races and stuff, right? And that's done in some official capacity where the charter applies, then that's totally against the law. And but in some ways, reasonable limits say, well, sometimes it's okay if there's a violation of a right if it's in some way necessary for a greater good, or if it's also not over the top, if it's proportional. So this is basically what they call the Oakes test. It's a two-stage procedure that the Supreme Court of Canada developed in figuring out, well, what's a reasonable limit on any right that's been violated. So, number one, the violation must be justified by a pressing and substantial objective, right? So, think about Ross, for instance, right? The Ross case. The pressing and substantial objective here would be, to secure education, a proper discrimination-free education for students, right? And you've got this anti-Semite, and he's fomenting all this bigotry and stuff. So we need to not have him teach anymore, and he needs to be censored for doing this, his freedom of speech, in order to obtain this pressing and substantial objective, which is education, and it's a really good objective, right? And then number two, the second half of the procedure in the Oakes test is that whatever legislative means that you pick, this law that you make that maybe violates or curtails a right or something, it has to be proportional to that objective, All right. So what does that mean? The proportionality test means that the law, whatever the law is that you've made, it mustn't be arbitrary, right? So it has to have a rational connection to the purpose of, say, discrimination-free education or something like that. And the law, secondly, the legal means chosen must minimally impair the infringed right. So it has to be the least drastic means. You don't go after a fly with a ball peen hammer, right, or a sledgehammer, or you use a fly swatter, right? So what is the least drastic means? If a right needs to be violated, maybe there are more subtle or less extreme ways of violating the right, something like that. And then third is the cost of legislative means must be proportional to the benefit. So, if you're curtailing a right, or if you're stomping on somebody's right in some fashion, if you're violating it in some degree, is the payoff for that violation worth it for the benefits to the general welfare, right? That is the idea of proportionality in the three parts of the proportionality test. Okay, so those were the considerations anytime. Those are the considerations anytime the Charter of Rights and Freedoms is invoked in education, law, litigation, or any other kind of litigation. The Oakes test is always considered once a right is actually found to have been violated, ladies and gentlemen. Okay, that's enough today on role models in education. I hope that you found that helpful. I hope you'll be thinking a little bit about how your own lives outside of your classroom, your own private lives are connected to you as a teacher. You'll keep that in mind. Enjoy your trips to Europe, but maybe keep your pictures of yourself with a beer, if you are so inclined. Maybe keep them to yourself, or that sort of thing. I don't know. Good luck to you.